Thanks all for coming to this debate on UK's rape laws and whether they need reform, whether they become too politicised, and whether they are facing an impossible uphill battle against the ever-complex definition of what constitutes consent. My name is Izzy Lyons. I'll be your chair this afternoon. I'm going to avoid waffling on because we've got some excellent panellists and I want them to speak for as long as possible and then obviously to come out to you guys for some questions. So I'm going to introduce them in the order in which they're going to speak. They'll then make their opening statements for about 5 to 7 minutes, and then we're going to come out to you guys for some questions, so have them ready, and I've no doubt there'll be plenty of them. Firstly, we have Liam Allen. Liam was falsely accused of rape by a previous partner in 2016. However, his case collapsed in December last year after vital evidence proving his innocence came to light. The officer in charge was found to have failed to disclose the vital evidence proving his innocence. And since his case, Liam has co-founded the campaign called Innovation of Justice, which aims to assist in making the necessary changes to prevent miscarriages of justice and raise awareness around the topic. Next, we have Rob Beckley. Rob is the Assistant Commissioner of the Metropolitan Police. He recently wrote a review into the police policy of believing the victim, which I'm sure he'll shed some light on this afternoon. Next, we have Matthew Scott, to my left, who is a criminal barrister as well as a legal blogger, writing frequently for titles such as The Times and The Daily Telegraph. He considers himself broadly on the right of politics and believes in freedom of speech and the freedom to do more or less anything unless it harms others. On my far right is Hannah Bowes. She is an assistant professor in criminal law at Durham Law School and deputy director of the Centre for Research into Violence and Abuse. Her research interests are largely around age, gender, and socio-cultural causes of violence against women. And lastly, on my far left, we have Ella Whelan. She is a journalist and the author of What Women Want, Fun, Freedom, and an End to Feminism. And she regularly appears on TV debates and writes for a host of national titles such as The Sun, The Sunday Times, and The Economist. So without further ado, do you want to kick us off, Liam?
So I was falsely accused of multiple rape by a previous partner. There were a lot of things that sort of just went wrong, legally, morally, with the police investigation all the way through to court. And things have just sort of come to my attention that, aren't necessarily in the public eye before. And I think the first thing I'll probably start with that I'm in support of is educating people from a relatively young age. We do sex education in classes, but I don't think once consent or the word rape or exactly the meanings of each one was ever explained to anybody. And I think it would help both rape victims and the falsely accused for people that are going to report rape to know exactly what it is that they're reporting and what constitutes that. And I think it will help rape victims in the sense of men will know how to behave and exactly what is and isn't considered consent without any blurred lines, in a sense. The other part of it was probably the biggest part was disclosure. As far as I'm aware, it is a legal requirement for police and the prosecution to hand over any evidence that assists the defence or undermines a prosecution. At present, it seems that in rape cases specifically and in other cases as well, that isn't really being followed up or enforced in a sense, or there are often times where mistakes are made and it's only caught out in some cases right at the very last minute and probably in a lot of others that they weren't. I am co-founder of Innovation of Justice, which is looking at things like that and trying to make changes to the criminal justice system to help with those kinds of issues and help stop another person like myself ending up where I am today and having to speak about things like this.
Rob,
Thank you. There's quite a few dimensions in this topic. I'm going to just address two in my opening comments. One is about just the sheer scale and the context and the legal context of what we deal with now. And the second is about the belief piece of work. There's some really interesting asides that we'll perhaps explore around things like the social media and certainly the issues of consent, but we can explore that in discussion. 2 health warnings, please. I am currently leading investigations into Hillsborough and what happened up to and on the day of the disaster. They're going to court. I will not speak at all about that for legal reasons, and also you must not assume that anything I say has any bearing upon that case. I'm only going to talk about issues that I've discovered, primarily doing the review into believing victims. That is a policing policy. My second caveat is that I'm of the Metropolitan Police, but not in it. They employ me. They're the only organisation that can employ more than one chief constable, so therefore I am housed by them. But what I say today is nothing to do officially with any Metropolitan Police policy. It's my own experience as a police officer over many years and my own observations and views on that. Firstly, how many people here remembers 1992? Just go and stick your head up if you remember 1992. So actually, quite a lot of people don't, which really does make you feel desperately old, because it was the time when I last investigated a serious sexual offence myself and managed the whole process of investigation. I've overseen many since, but that was the last time I managed it. I dealt with a serious crime in the Academy in Brixton, as many of you will know that venue, and I won't go into any detail other than to say that on a wet, miserable November night, well, it was early in the morning, about 3 or 4 o'clock, when most of the punters had gone, we started investigation, and by the time the file was concluded, I had about 7 statements. I had some photographs from the forensic medical examiner. I had the ticket stubs for the offender, the suspect, and the complainant exhibited, and that was about the extent of the evidential package. And it was then up for a debate if it got to court, and that case actually didn't get to court, but if it got to court, on the strengths and weaknesses of the case. And at one point I did look at the victim's address book, because she said she knew the person before and he said he hadn't. So that's the description of my work that took me a couple of weeks, diligent activity. Now, believe me, the scale, it's off the scale. You only have to think about the potential sources of evidence that could come from your mobile phone to begin with, the CCTV, both inside and outside the venue, the CCTV along the road, the movement of people on their Oyster card, the whole picture that you can now draw together it's almost indescribable. You download a social media app onto paper, and you can end up with hundreds of pages. And of course, that's the scale of a lot of what these investigations now require. And my premise, what I would say, and we can go into a bit more detail, is the capability and capacity of policing and the legal system to manage that process is just simply not there. It is a scale that it's off the scale. It requires significant amount of focus and person power in it. It requires a legal process that is more than just a ping-pong game of tennis. It actually requires a little bit more collective endeavour, a bit of inquisitorial approach rather than an adversarial approach, but our current processes for disclosure just don't work with that mass of material. And then you throw into the mix an issue of belief that I've looked in some depth on. And this is a policy brought in because of the anxiety across policing and across the broader criminal justice system that we are filtering, that the police and other are filtering the cuffing the offences before they ever reach investigation. So therefore we must approach it by believing the victim, and therefore ensuring that first accounts are done with an approach of belief. Because there is good evidence to suggest that fear of disbelief is a real barrier to people reporting their sexual offences. And that's true. But fear of disbelief doesn't mean to say that the institution that's required to investigate should do the diametrically opposite, which is believe. When you look at the evidence, it's actually fear of disbelief, but it's not that then police should believe. It's actually that police should then take it seriously, show empathy, do a decent investigation, show concern for welfare and manage the risks, manage understand the offence and the consequences of the offence. If you show that as a cop, That's taking it seriously, but not just believing. And why I'm anxious about believing and the policy that the police have adopted, being reconsidered in the light of my report, is that it creates a mindset at the start of an investigation. You have to approach it, not professionally, but dispassionately in terms of where does the evidence take you. And against the backdrop I described of such an enormous amount of potential evidence, where people are making choices about what they look at and what they don't, having a mindset that takes you in a certain direction very early on, I think, is a risk. So I have recommended to the police service that we remove that policy of believing victims, not because I don't want victims to get their best possible service, but because I do think it's in very dangerous territory and is causing problems, perhaps related to some of what Liam was talking about a little bit earlier.
Thank you.
Well, I hope Rob's recommendations are accepted by the Met. Now, did all of you, or any of you, watch the Judge Kavanagh confirmation hearings? Put your hands up if you watched them. So that's probably about 2/3 of you, I should think. And did any of you come down on one side or the other? Did any of you believe that, any of you sure that she was telling the truth? So it's about 5, 10, perhaps, people. Any of you sure that he was telling the truth? Looks like about 2 or 3. And the rest of you were not sure, somewhere in the middle. That, of course, wasn't a criminal trial, but it had quite a lot of similarities to the sort of thing that happens in criminal courts in this country. Of course, all the procedure is a little bit different, but a lot of cases, not just sex cases, but particularly sex cases, do, in the end, boil down to who is telling the truth. Who do you believe? And the fact of the matter is, psychological research tells us that people aren't very good at telling when someone is lying and when someone is telling the truth. And we've seen that in legal history again and again. People have been convicted. Juries have been quite sure that they've been lied to. I mean, we can go back a long way, if you like, to the Irish cases in the 70s and 80s. The Guildford 4 and the Birmingham 6, I think they all gave evidence, all telling the truth that they'd been horribly maltreated by the West Midlands police and stitched up. Well, our juries ought to be able to see, well, these people are obviously telling the truth. They couldn't. All 10 were convicted by juries. In rape cases, sometimes, of course, we do have good evidence. We might have evidence from a forensic medical examiner, such as we heard about just now, or we might have evidence about people's movements to show that someone's lying about some important part of the case. Of course, that can happen. But very, very often, it comes down to that simple question, who is telling the truth? And our legal system, and I think this is a real problem with our legal system, that it trusts juries to just accept that one party or the other must be telling the truth, even when there may be no corroborating evidence at all. If Liam had been put on trial, I think you were put on trial, but if Liam's trial had gone the distance, the jury would have decided that case without knowing what was in those text messages, which completely exonerated him. That case had been reviewed by the police, by the CPS. They thought it stood a realistic prospect of a conviction. They thought they had the evidence to put him behind bars because of one person's word. And that's very, very dangerous. And I think it's got more dangerous in recent years. Now, before I go on, I don't want anyone to get from this that I don't think there's a problem with women being raped and sexually assaulted on a very large scale and often completely below the radar of the law. Anyone who looks at the statistics from, for example, the British Crime Survey, not what's been reported to the police, but what people tell the British Crime Survey, or I think it's now called the Crime Survey England and Wales, it's perfectly obvious there are thousands and thousands of women and some men who are sexually assaulted and for all sorts of reasons don't report it and don't get justice. So there is a problem. But you can't deal with that problem by simply making convictions easier. Because when you do that, you're going to get injustice. If there's one thing that a criminal justice system ought to do, even beyond convicting the guilty, it's to be sure it does not convict the innocent, people like Liam here, and other people that we've seen. And it's been deliberately made over the last few decades and years, it's been made easier and easier to convict people. That I think the last change in the law which assisted the defence, and a very important change, but it was back in 1984 with the Police and Criminal Evidence Act, which brought in restrictions and rules about how the police should treat people in custody, amongst other things. Lots of important things, but that perhaps one of the most important. But that aside, one just has to look at the changes in the law. Lots of them, they seem individually quite sensible, maybe some of them less sensible, but the cumulative effect is that convictions have become easier to get, and the risk, therefore, and especially, in, not only, but especially in sex cases, the risk of wrongful convictions has grown. And just before I wind up, if you want to really get a feel for this, can I suggest you go to the archive of the newspaper for prisoners called Inside Time, which published a letter from the wife of a woman who had, the wife of a man who had been convicted of a historic sex case. It's quite a moving letter because she believes him to be innocent. And look at the comments below that letter. There's a flood of people all saying the same thing, that they do not any longer have any confidence in a justice system which allows people to be convicted on uncorroborated evidence, often after many decades. They feel there is something very seriously amiss there. And I feel, too, that in the same way, rather, that we were all too ready to convict people of terrorist offences in the 70s and 80s, there is a real danger that because of our disapproval and dislike of the crime of rape, that we are making it too easy to convict people.
Thank you, Matthew. Anna, do you want to?
Okay, so I think for me, in addressing the overarching question and the title of this session, which is how good are the UK's rape laws, my view is that the issues are less to do with the law and more to do with the criminal justice system that surrounds the law, some of which has been touched upon already by other panellists. And I think before considering some of those issues, it's important to acknowledge that the criminal justice system is not about objective truth or finding out the objective truth of a suspect's guilt or innocence, but instead it's really a contest, and it's about two sides putting across their view of events and left, as we've already heard, for juries to make decisions about who they believe. And actually, this contest affects the process, outcomes and decisions at all stages of the criminal justice system, which creates some problems. So we know that sexual violence is prevalent. As we've already heard, we know that the scale from surveys like the Crime Survey for England and Wales is huge. And in fact, globally, it's estimated that around 35% of women will experience some form of sexual violence in their lifetime. However, the best available evidence indicates that only around 15% of people who experience sexual violence go on to report that to the police, again, as we've heard already. And the reasons for this underreporting are complex, but the research over the last few decades has suggested that some of the most common reasons for not reporting are a fear of not being believed, again, as we've already heard about, a fear of repercussions, usually from the perpetrator, but sometimes from other people, from society more generally, and also a fear of going through the criminal justice process. And these fears are not unfounded. So if we think about some of the data that we have available to us at a national level, so this is data provided by the CPS or the Crime Survey or the police. We know that when women do report, and not just women, of course, but primarily when women do report sexual offences, they are often not recorded as such by the police. So a recent large-scale national review of policing in relation to all offences, actually, but with a focus on sexual offences, by the HMIC, found that around 26% of sexual offences that should have been recorded as a crime were not recorded as a crime when the police took the decision not to record those as crimes. Prosecutions also remain low. So we know that in the year 2017, the police recorded just over 41,000 rapes in that year. But only 16% of those ended up being referred to the CPS, the Crown Prosecution Service. And actually, in total, only 9% of that 41,000 ended up being charged. You may well have heard over the last few weeks, we've had The Guardian and other newspapers publishing stories about the CPS being given guidance to not take forward weak cases. And I think that partially exposes some of the issues that we have in terms of the judgments that are made about cases that should or shouldn't be prosecuted. We also know, so going back to one of the other fears that women have, or reasons why they don't report, their fear of repercussions, that also is not unfounded. So for women, they are around 75% more at risk when they leave somebody who is abusive in terms of serious violence or death. And actually, when we know that the vast majority of sexual violence does happen in a relationship. So actually, women are not, that risk is real for them, because we know that actually you are most at risk when you attempt to leave an abusive relationship. Okay, so when cases do reach court then, so often research has shown us that often the focus is as much on the victim as it is on the defendant. And in some cases that has led people to describe experiencing secondary trauma. Sometimes it's been described as experiencing a form of rape all over again. Because the things that are on trial for the victim tend to be issues that often are not directly related to the case. So it might be, for example, how they've chosen to dress on the evening or how much alcohol they've consumed. In some cases, they will be relevant to the matter, but in others, they're not, and they are often used as a way of discrediting or maligning victims rather than actually investigating the issues at hand. Okay, I guess then to summarise, I think it's clear that there are significant issues with the criminal justice system in terms of how we encourage people to report, but then when they do report rape and sexual offences, ensuring that the system is effective and works properly in investigating those cases, because a properly functioning criminal justice system is absolutely needed to make sure that we have fairness not only for victims but also for defendants in rape cases as well. Thank you.
And Ella, we'll finish with you.
Thank you. I think you'd be a bit of a fool to think that the criminal justice system was perfect. I think on both sides, whether people say that it's swayed against women or whether it's swayed against men, we can kind of agree that there's certainly something to talk about in relation to rape laws and how we deal with rape. There's a hangover from decades ago when women weren't treated seriously, and there's a hangover of feeling of injustice at that, and I would completely believe that some women, certainly of a certain age, would feel that it was useless to go to the police in cases like this because police don't treat these things seriously. I also think it's completely credible that there are some guys potentially out there who are now feeling nervous about the fact that the CPS is currently reviewing a huge number of its cases, similar to Liam's, in relation to a miscarriage of justice. What I want to do in my short time is sort of row back from the focus on the law and actually look at how we're talking about rape, because this really fascinates me, and specifically how we're talking about and how we're thinking about rape and in relation to how it affects women. Because it's people often say, of course, rape is terrible, and that always sort of makes me pause for thought, because if you have to say of course something, then why say it at all? But most decent people will say that being raped is, at the very least, not a pleasant experience. But on the other hand, I think what's happening today is that the way that we talk about rape and women who have been raped is sort of going a bit too extreme. So the suggestion that a woman who has been raped, who's been a victim of rape, has forever changed and is no longer a woman but is a victim, a survivor of sexual abuse, a survivor of rape, is very interesting, because what's happened there is that that act which happened to that woman outside of her own control, I'm going to go with saying women here, though I know it does also happen to men, but let's stick with women, because it's central to my point. The woman is raped, her agency is removed, it's something that she didn't want to happen. And the way that we now talk about rape and sort of position women as survivors of rape, as victims in the I believe her frame of thought, is that forevermore, that instance, whether it took an hour or 10 minutes or a day, whatever it was, that act that was wrong and that happened to that woman will then be assigned to her for the rest of her life. You have people talking about being victims of abuse, victims of assault, victims of rape. And I'm very uncomfortable with that. I'm very uncomfortable at the way that we see rape happening to women as almost like a scarlet letter. You kind of have it slapped on your back, and that's the badge that you wear for the rest of your life. You are a rape victim. I think this is really being reflected in the way that the law is dealing with this, specifically around the I Believe Her movement, around the calls to change rape law in relation to being softer on accusers, softer on complainants, anonymizing certain parts of it. Because what this is really saying is that this act has so fundamentally changed this woman, has had such a detrimental effect on her life and her very being, that she cannot be treated the same any longer. She has to be given special measures, whether it goes to trial or has to be treated very differently to any other kind of complainant. She has to be believed, which means that she's stripped of all agency. The possibility for her to have done wrong, in the same as the accused, the possibility for her to say something that isn't true is removed. She's like a child. She's just absolutely believed. There's no agency within there. But more importantly, she is fundamentally different. This rape is the most terrible thing that could happen to her, and she will never again be the woman that she was prior to that instance. She will forevermore be a victim. And now, Germaine Greer got a lot of stick this year for talking about rape, and she published a book, I think mainly to get headlines, but there you go. She published a book called On Rape. I went to see her speak about it at a festival, and there was gasps of intakes of breath when she said, do you know what, I think rape isn't that bad. And this is what she's partly famous for saying that she would rather be rather be raped than stabbed. And she says that rape isn't particularly that bad. And people's personal experiences of this cannot be compared, because everyone is different, and for what is a terrible thing for one person might be the slightest thing for another person. But there's something interesting in what Greer is saying, because I think what she's saying is that we are in our almost obsession with rape and our obsession of its negative effects and lasting effects on women, people talking about PTSD and this kind of thing, is making a value judgment on how we view women and how we view women's agency and how we view women's resilience. I mean, as it happens, most of the women that I talk to who talk about rape culture, who talk about the issue of changing UK rape laws, are young women who are my friends who I know haven't experienced sexual assault or rape. As it happens, there are quite a number of older women from an older generation who I know who have been raped, who say that it isn't the worst thing that's happened to them in their lives, that they don't lie awake thinking about it, that they don't have lasting effect from it. So there's something interesting going on there in relation to the difference of how we're now thinking about rape. Just to summarise, this really was brought into sharp focus for me, and I wrote about it in the book, by the mattress girl. Does anyone know the mattress girl, Emma Sulkowicz, in a university in America? Now, she alleged that one of her fellow university colleagues had raped her. It was dealt with under the policy Title IX, I believe it is, in America, where it's sort of, you can call it kangaroo courts on campus. Anyway, he was cleared, he was acquitted, I believe. He was cleared of, no one believed that he had raped her, it was thrown out. She decided to carry her mattress as a piece of art throughout the rest of her degree, which was a number of years, as a symbol of the fact that she had been raped and she had not received justice. She literally wore her rape, or her alleged rape, on her back. I think that positioning of women, of raped women, as the kind of wearing that experience on your back, as it becoming central to your identity, seems to me, whatever changes we make in the law, very, very dark and wrong way to treat rape and to treat victims of rape, and a really, really bad way of looking at women's agency.
Thank you. So I'm conscious that we only have 45 minutes, so I'm going to come straight back out to you guys.
I think, like with most sexism issues, there's quite an interesting flip side to that issue as well. While we view rape as being the worst thing that can happen to a woman, on the flip side, it's also viewed as the worst thing anyone could do, and like rapists must be monsters. And I think that takes away a lot of the shades of gray that might be in any crime, where there are some cases that are brutal and possibly some of the worst things that can happen to someone in some cases or something, while still being horrible that someone can get over. And I think that translates into sentencing as well, which, I mean, don't know as many British cases, but in the US, for example, you get Brock Turner, who had got a really short sentence for the rape he committed, and you see a lot of bias there because a judge might think, oh, that kid looks like my kid, he can't be a monster or, the worst thing humanity can produce. And, a jury, again, might see a girl and be like, oh, she looks like my daughter, this person should go to jail forever. And in that sense, this sort of intense emotional attachment we have to this specific crime, I think really biases sentencing. Do you have any thoughts on that?
I recently read Jermaine's rape book, and I took a second point from it, Ellen. So it's a question for all the panel. So there was the point that you raised that I kind of noticed, but the whole thrust of the book seemed to be taking logically consent and then working it from an area of clear, where consent doesn't exist, as it were, stranger, violent, that kind of situation, and then right the way, what I would describe, I mean, I'm not trying to offend anybody, but right the way down to examples where she gives the example of a husband and wife, 20 years married. He says, darling, do you fancy sex? She says, I'd rather not love. But then she ends up going sort of, okay then. And then she says, well, consent doesn't exist there. And in principle and logically, consent not existing in that experience is exactly the same as consent not experience in the other one. Now, from a personal perspective, and again, I could be completely wrong about this, it feels like over my kind of adult life, over the last kind of 30 years or so, that's also what's kind of happened at a national, in the UK anyway, a national debate. You kind of knew what rape was. It was this reported in the papers, somebody was raped walking home by a stranger, and then has gradually moved towards, as it were, where Jermaine says, argues logically, I wonder what you think, most sex in this country is done without consent, therefore most sex is rape. So my question is that, because this is about the law, taking her point, is it time now to sort of reconsider consent as the defining characteristic of rape and trying to draw or redefine what it is, if it is the case that most sex in this country is non-consensual and therefore rape?
I think it is a really interesting point that you've raised, Ella, there about rape. And the way that I've always thought about it is that it's a particularly horrific crime because of the way that it takes intimacy, something that should be intimate and private, and turns that into a weapon. That's what the rapist does, violates intimacy and violates our notion of intimacy. And I think it is quite interesting to think about that today, when actually intimacy much more broadly is questioned. So the whole discussion around consent and consent classes, to me, actually says intimacy itself is perhaps problematic in a much wider sense than before. And that must have then an impact on the way that we see rape and understand rape. And in some ways, I don't know if that's in some ways, whereas it's seen as this horrific thing, it also does seem to be trivialised at the same time. And I kind of think you can't understand that without understanding something that's changed about intimacy.
Brilliant, thanks.
Just something that Hannah said about how a potential victim would be considered what they wore, how much alcohol they drank, etc. I think it must be essential to teach boys and girls, as you teach them sexual education at school, like, that is not an explanation or a justification for any kind of sexual assault, because by making that an explanation or a justification, it degrades the act of rape or sexual assault to something that it shouldn't be degraded to.
Brilliant, thank you. Right, so we're going to come back to the panellists. Don't feel like you have to answer every single one of those questions, because I feel like there were quite a few. But if we start with you, Hannah, and then we'll go along. I'm interested in your idea on consent. Is it something that we can police, or is it too much of a grey area, do you think?
Well, it is a grey area, I think, in terms of how it is defined, or perhaps not particularly well defined in the legislation. And I think that there have been a lot of moves over the last few years to try and to really think about what we mean by consent. And obviously there have been various kind of pushes towards having enthusiastic consent or affirmative consent, which tend to be quite popular buzzwords in the US for this. But I think in terms of in terms of the definition of consent, I think there has been some confusion, because we haven't been very good at building it into our sex education. In fact, if I think back to my own sex education at school, it lasted about 15 minutes, and it was very much related to the biological functioning of various sexual organs, and not much more than that. And there was never any discussion about actually what consent was and how that would fit into having sex, and actually what consent would mean. And so I think because of that, because we haven't had that embedded in our education system, it's been left too much to people to make it up as they go along in some cases, because we haven't had that kind of set criteria, really embedded. So whilst the law in some ways is quite clear about what consent should mean, I think the lack of a broader understanding and discussion about what consent is has led to some of the grey areas that we now see that create this tension between society and the law.
Brilliant, thanks. Rob, any?
Yeah, the first question I talked about shades of grey, and I'm trying to get that film out of my mind. But it is shades of grey. We're talking about the law having to referee often very messy human interactions, and that's not a straightforward matter. And actually the law isn't very good at it, in the sense that if you're looking at it as an adversarial matter where you're challenging a fact, often it's the whole picture that you're trying to describe. That you talked about. Thankfully, we've moved beyond the time when the judge would talk about contributory negligence in the way somebody dressed or what they did. But nevertheless, you have to look at the whole picture and understand what on earth happened here. And I don't think the law's very good, really. It tries to focus in. I often describe it like a game of tennis, where the ball goes one way and you just look at where the ball lands. You don't look at the whole tennis court and ask yourself, what's gone on here? And so it is difficult and messy, and it's exemplified by two things. One is in the context of sexual offences, it's almost a no-no to have any form of restorative justice. If anybody is aware of restorative justice, it's around trying to repair the harm and not take it through necessarily a criminal process, But it tends in the UK, not so much in Australia and elsewhere, but it tends in the UK to be limited to your criminal damage or your minor theft. And yet, often, these things are about managing the human side of it, not the legal niceties in it. And the second exemplification of that is I'm fascinated by the use, and I've seen doing my review, the use of Tinder and Grindr and other such social apps. And what's that actually doing? It's changing the rules of engagement. The rules of engagement were always messy, and I think the talk about consent and being taught about consent is quite an interest. You know, it's really interesting because I think that's right. I don't think we don't talk about it. And there's some, but when you go on some of these social apps, there aren't. You know, the rules are almost circumvented, and in that context, I've seen through the officers who were showing me some of their cases, times when you're seeing real exploitation potentially of people through those apps, and I think predatory behaviour. But you're also seeing at the other end of the scale a lot of regret activity, and what might be called regret sex, but nevertheless, you've got some behaviours because the rules aren't there and consent isn't negotiated, people just making assumptions in the process. So I think it throws up some really interesting questions. I don't know the answer on that one in particular. I think Hannah's done some fantastic work in looking at areas of sexual offences that people tend to look at less. I think this is an area that we need to explore more.
Brilliant, thank you. Do you, Matthew?
Well, I was struck that two people in this room listened to Germaine Greer and managed to make some sense of what she was saying. Because to me, she seemed completely incoherent. And well done to Ella and the gentleman over there. But you make a good point, sir, that rape does cover a multitude of behaviour, and one can get torn apart for saying that some rapes are worse than others. Undoubtedly, some rapes are worse than others. And that's recognised by the law in the sentencing guidelines, where sentences of 20, 30 years or life imprisonment are given for the worst rapes, and much shorter sentences, but not often less than about 8 years, for what might be called the least serious rapes. I'm a little troubled by Ella's assertion that really, perhaps I paraphrase it, that women should just get over it when they've been raped, because people's lives are ruined by rape. I can think of at least two people known to me personally whose lives apparently have been completely ruined by rapes when they were very young. But equally, coming back to I think Hannah made the point about why rapes are often not reported. The commonest reason, in fact, given in the survey by the Crime Survey England and Wales, and has been over a large number of years, the most common reason isn't anything to do with thinking that people won't believe you or thinking that the police will treat you badly. The most common reason given is embarrassment, and that's been consistent over many, many years. So I think it's a little dangerous to assume, and it's almost its own rape myth, that the criminal justice system is somehow cruel and unkind to rapists. And yes, of course it does happen sometimes that people are very badly treated in trials. And of course, if there is a criminal trial about anything, it's a pretty bruising experience sometimes to be a witness. But it's not true that routinely women are given a hard time about what they were wearing. It's not true, for example, that women are often asked about their previous sexual experience in rape trials. That's very rare. You've got to make an application to the judge to do that, and those applications aren't that often made and are very often refused when they are made. So there are a lot of myths about this. There's another myth is that when people report rape to the police, they think they're going to be badly treated by the police. Again, you look at the survey from the Crime Survey England and Wales, most people, complainants who reported their rapes to the police, actually thought the police had been very helpful. And they thought that at the beginning of the investigation, slightly less at the end, but still they generally thought that the police had been very helpful. So we've got to be a little bit careful about this sort of rather lazy assumption that people who report rape are treated badly. But anyway, I don't know whether that's very coherent either.
Thank you, Matthew.
Hopefully better than Jermaine.
Liam, I don't know if you wanted to pick up on any of the points that the audience made, or
So now we're at a point probably where consent is interpretive to the person. So a lot of conversations when people are speaking about it, they speak about, well, you spoke about alcohol on those levels, and you know, we've spoken about, I think my mum spoke about after this case, regret, which I think you brushed up on as well. And a lot of the time it seems to be that a lot of people are starting to see that if they look back on things, and a lot of the time it's in historic cases as well, and it's not all, don't get me wrong, I'm very aware that there's real rape victims as well, but a lot of it is looking back and thinking, if I was in a different mindset, or if I was in the mindset I'm in today, would I have gone there? And if they say no, I think it starts to become their interpretation of, well then, surely there must have there been some form of sexual assault or rape, because I don't feel I would have consented now, so I couldn't have properly consented then. And it's difficult to retrospectively look back on these things as well, bearing in mind, especially with historic cases. But with consent, and the law partly defines it, but everyone in this room, if you think about all the times that you've had sex, a lot of it is in the heat of the moment. You know, there's not, depends on how far along in the relationship you are, but there's not really a point that, you know, you turn around and you go, should we do it now? You know, it doesn't happen. It just doesn't. And it's so frustrating to hear the words believe as well in a lot of this, is that, why is it about belief? It's not. It's about what is in front of you, the facts. The facts are the facts. The point of it is, when it gets to a jury, if somebody is convicted, it has to be beyond reasonable doubt. That doesn't mean I believe they did it. That means I believe the facts show that they did it. That the evidence is leading me towards doing that. You can never, ever be sure, 110%, that consent was or wasn't given in a situation if it's one word against another, which means it can never be beyond reasonable doubt. And I think the avenue there, the bit that people are missing is, yes, they could get closure from justice, the justice system working and finding out all the information that they need to find out. I completely understand that. But about the mental health, you know, the trauma, I know you were speaking about how, you know, maybe people, well, you paraphrased it to people should get over it, and I don't think that's probably what you were quite getting at in that respect. And I know there's a lot of conversation about taking away the seriousness of the subject, but you can't take away how that's going to affect somebody individually. You never know if that is going to completely destroy them, or as you said, you know, they can just move past it. And the justice system seems to fail to, they miss the personal side of it. Cases are just seen as that, just cases. And I think there needs to be a risk assessment in that this has caused a lot of trauma. Whether or not this person gets convicted, that person is going to need to be referred to for support. And you know, that's the hardest bit for me, is that justice isn't always getting a conviction, and that's how it's always seen. I think justice is getting closure, and if you can't get closure in one avenue because you can't prove the consent side of it, then there needs to be some form of closure in another avenue, like mental health support, like support groups, and you know, that kind of support. That's what's missing for me.
Thank you, Liam. Ella, I don't know if you want to come back on any of the points Liam made, or back into the audience.
I'll just make 2 points. The first one was that I was not saying that women should just get over it, although I don't think that's a particularly negative way to look at it either. Each person should have their own individual way of dealing with something like that, and they should be supported. It wasn't about devaluing the seriousness of rape, but the point that I was trying to make is quite a difficult one to make, which is why I'm picking my words quite carefully, is that I don't think justice is best served if we encourage women to view that act of injustice as being part of their identity after the fact. I think that's where I see the discussion about rape going today, especially in relation to lots of contemporary feminist campaigns around rape, whether it be I Believe Her or Believe the Victim or even Me Too, is that thing that happens to you becomes part of your identity. You become a victim, a survivor, you become a Me Tooer, as it were. And that doesn't seem like justice either. It doesn't seem like justice to prolong the act that that man or whoever it was did to you into the next 20 years of your life and part of your identity. That's what I'm trying to get at. There's a really great point made about intimacy and the difference between this sort of contradiction in relation to how we look at intimacy and how we should deal with it. I'm so not on board with the discussion about consent that's been had on the panel. I think that consent classes are bizarre and dystopian and abhorrent, and you wouldn't drag me screaming into one of them. And that's specifically because it is ridiculous to suggest that consent classes prevent rapes from happening. A rapist does not rape you because he doesn't understand consent. He does it despite consent. The rapist does it whether or not you consent or not. There's no discussion being had there necessarily. I mean, this is the point that Germaine Greer fundamentally misses, that actually within that relationship between a man and a woman, there is something called implied consent, potentially. So you don't necessarily have to, every time I turn to my partner and, fancy it, I don't have to say, do we consent, do you consent? It kind of kills the mood, This is not teaching people about consent. If you need to be taught about consent, really, if you need to really be taught that if someone's saying no, that you think that's all right, then you've got bigger problems than can be dealt with some poxy university conference, right? But just to end with, about where this goes for intimacy, and specifically where this goes for women's relationship with intimacy, because I'm reading some quite worrying stats and surveys and headlines coming out now about especially young people and young women's relationship with sex, and about them being nervous about going to university because they think they're going to get raped on university, even though rates of rape at university are minuscule. Young people saying they'd rather not have sex because they think it's too risky, they don't understand consent, all of this stuff. I mean, if the end result of our dealings with rape and serious sexual violence like that is that we're teaching people that that sex is a danger to be navigated and weaved your way through, rather than one of the most, I'm not trying to be flippant here, the most enjoyable aspects of adult life, intimacy and sex and relationships, well, that seems to me like we're completely missing the point of what we're getting here, which is that more people should be having better sex rather than having negative experiences.
Brilliant, thanks, Ella. I'm going to come back out for another round of questions.
Yes, I mean, I don't know much about the law itself, and I would be interested to know what people think about the disjuncture between the law itself and this much wider discussion about rape. Because the thing I think there's a kind of collective madness going on in the discussion about rape in the broadest sense. So when you listen to Me Too or the Kavanaugh hearings, I don't reckon it's a completely new phenomenon to somebody like me who came of age in the late 80s, 90s, if I remember. So when we had no sense that when you were with somebody who you liked, that they could harm you. That just did not enter our minds. Rape really was the thing that happened from somebody who was malevolent. It was the guy, we might have had a misapprehension that it was always the guy in the bushes in the park, but at the same time, the idea that somehow it's everywhere, it could be my husband tomorrow, or that's just it is dystopian. It's a very peculiar way of looking at the world, and that's a transformation in where we understand harm lying. And the very fact that people could question, well, have I been raped? Well, if you don't know, then you probably haven't. To me, that's a very strange idea. And you see this on online boards all the time. I don't quite know how I feel about this. My boyfriend did this last night, and I was a bit drunk, and he didn't really stop when I grunted. People say, oh my God, you have been raped, go straight to the police straight away. And I think, wow, that's a total transformation in the idea of the mess of intimate life, and the idea that you could clean it up through law or through consent classes. What are you going to teach in consent classes? What do you teach? I mean, maybe you can give them a bit of statute, but how, like Ella says, how is that going to help? Given that most people will never be raped, why on earth would you tell everybody that that's a possibility, to either boys or girls, and particularly young ages? I mean, I think that's a very perverse idea. that somehow, as you're telling young people about sex education, you also tell them that the harm that they are quite likely to experience or do to one another. I think that is just perverse.
My 19-year-old son's best friend was accused of rape, and a year later it came to court. Facts emerged at the trial that, without going into the details, showed that it couldn't have been rape, and he was found unanimously not guilty, thank goodness, in a very short space of time. I sat through the trial from beginning to end, and obviously with the boy concerned being my son's best friend, that was very much where my loyalties were going into the trial. Surprisingly, however, over the course of the 3 days of this trial, I actually began to feel incredibly sympathetic towards the young woman. I don't believe she was lying about what happened. I think what had happened was that various people who had taken an interest in this from the beginning, had told her that what she had experienced was rape. And I would include in that consent classes. One of my many problems with consent classes is that they redefine rape, or they put a definition of rape as unwanted sex, which doesn't stand up in court. It's not the legal definition of rape, whereas young women are being told that if you have sex and you don't want to, even if the fact of not having wanted to is decided after the event, then you were raped. And so they go to court, they spend a year of their life believing they are a victim of rape. They go to court, they suffer just as much as the man does, the endurance of a rape trial, to then have the thing essentially thrown out of court. Nobody wins in this. It's terrible all round. And my fear is that the more we push for consent classes, the more we actually teach young women that they are going to be victims of rape and that unwanted sex is rape.
For those who would wish to alter the criminal justice system, precisely what changes do you propose? Precisely how would those work in the context of the criminal justice system as a whole? And exactly how would those maximise the extent to which the rule of law is upheld?
Love it. Nice and punchy. Perfect. Thank you. Can we come to you first? Any thoughts on that question in particular?
Yeah, it's a very difficult question. I think the changes in the law have gone, as I said at the beginning, too far in the direction of trying to convict people. There are quite a number of changes that I would make. Starting with criminal procedure, I would abolish the doc in criminal cases. You may say, well, how is that a change? We've always had docs. No, we haven't really. We've had an area at the back of the court where the defendant has sat in English trials. But over recent years, almost all criminal courts now have a ghastly glass cage, the sort of thing that Adolf Eichmann was tried in Israel. It's totally inappropriate. It's totally unfair. It's degrading for the defendant, and it's extremely prejudicial. So I would start. There's quite a long list of things which may not have time for, but I would start with abolishing the doc. There was another point that, the consent classes. Can I deal with?
Yeah, very quickly.
Can I very quickly deal with consent classes? I don't think consent is straightforward, but I think there may be something to be said for consent classes, but only if the people teaching them actually know what the law is. The lady who says up there, well, unwanted sex isn't rape. Well, you're absolutely right. Of course it's not. It's penetration without consent, which is not the same as unwanted sex. However, there are, as everyone's observed, lots of grey areas, and areas which may be considered grey by some people, which actually aren't. Sex while someone is asleep, sex while someone is drunk or affected by drugs, sex with people who may, for other reasons, not have capacity to consent, sex with people who are 16 or 15. There are a lot of areas where the law isn't clear on consent, and if people can be taught correctly what the law is, then I'm all for consent classes. I do have a strong suspicion, never having been to one myself, but I do have a strong suspicion that the people who teach them very often have an agenda and probably aren't terribly accurate in what the law is when they're teaching it. So I think you probably have a point, madam.
Brilliant, thank you. Hannah, what's your view on consent classes?
Well, I think it depends what we're talking about here. So my original point was not so much on consent classes, but I think that we need a wider discussion about consent, which starts at an earlier age, so that we're not just expecting people to make it up as they go along. Somebody in the audience said, I think it might have been somebody here, but sorry, I've tried to jot things down in order and lost the track a little bit, but somebody had mentioned that that these kind of consent classes can be really problematic because you should just know whether or not somebody is consenting. But actually, I think the problem is that sometimes people don't know because they don't really know what consent is, because it's not a discussion that's ever really had to have been had historically. So I don't think it is always clear what consent is, and I don't think it's always clear when somebody isn't consenting, because it can come down to a lot of different factors and people's own beliefs and myths and stereotypes about what sex is and what women's sexual preferences are and what consent might constitute. And I mean, for example, there have been some large surveys done with young people who have asked them whether or not anything other than saying no constitutes no consent. And for a lot of young people, they believe that the only way that you can not consent to having sex is by saying the word no. And actually, that's not true. You know, that simply isn't the case. That is not the single only way that you can not consent. And so I do think it's important to have the discussions. The content of any classes, obviously, we have to be very careful. And I do think that it is important to incorporate the law into that, so people are very clear on what the law says constitutes consent, or perhaps more importantly, a lack of consent.
Brilliant, thank you.
So I'm in school right now. I attend consent classes. We do get taught no is not the only way. There are other words. One thing that isn't discussed, though, is consent online. The amount of times I have been sent photos I didn't want, the amount of times my friends have been sent photos they didn't want, and although this isn't a physical act, it can affect you. It's not nice, it's not pleasant. And the amount of times I've gone back to school and not wanted to see people because they've sent me a photo, I'm worried they'll twist it so that it looks like I wanted it. And that's something that isn't discussed and should be discussed nowadays.
Brilliant, thank you.
Do we think, we mentioned here earlier that women of a certain age, and I'm probably in that group of the 80s and 90s, where actually we had discussions when we were younger where sexual assault with someone's brother touching you up, or genuine rape where we had a stranger rape, and even down to a friend's boyfriend beating them up and doing things they didn't want them to do, was actually quite commonplace because it had been normalised. But over time, in the last 20, 30 years, we've seen a lot of that change for the best, with some best endeavours, such as Me Too, may have come out to try and highlight that behaviour, and I think this is where we're getting around with consent and education, isn't in the right place from where it was 30 years ago. We've now moved to a new era, like we did with racism, like we have with homosexuality, around sex and women and their rights. But has this become a little bit of a hype with as well, in sense of the historical cases that are coming forward are being judged by a different set of standards today that mean today of where we're highlighting and educating people to what happened 30, 40 years ago. And I get with your point when you said people moved on. It was moved on because it was normalised. It doesn't necessarily make it right. It just doesn't necessarily make it stronger. It's are who we are. But there is a line now where sometimes I would probably look at something from being a certain age and thinking, really? That's going to court? And there are other bits where I could also challenge and understand. And I just want to point out here, I am actually Liam's mum. So with his case, totally threw me.
I'm not answering the questions, I'm terrified.
But totally threw me. But do you see a difference between what is a current case and standard to what historical cases are coming through?
I've had the pleasure of attending consent classes at my secondary school, college, and almost 4 now at my university. But I just like to kind of say, kind of directly to Matthew, you kind of pointed out a lot of the issues with the prosecuting rape and or like kind of like Liam's case. But isn't the problem with the offence of rape? It often boils down to one person's word against another, because that's how the case takes place you don't bring a witness. It's a bad idea if you're going to commit rape to bring a witness. And is that not really just a problem inherent with the offence of rape and prosecuting it, rather than the law or the criminal justice system?
Yeah, so just as a basic point, I think the problem with leaning the law in favour of one party or the other is that any wrongful conviction you have, you create not just possibly one extra victim of that crime, because you've got someone who something's happened to, a person who's wrongfully convicted, and potentially more extra victims who wrongfully believe that the rapist is now behind bars. So I think there's that issue where you wrongfully convict someone. And I also wanted just to say, do we not think there's a case to be had that we need to educate people on the basics of law, really, in school, so that we don't have these misconceptions about how cases are handled, things like that. I'm not saying everyone has to have a law degree, but, you know, just giving them that basics, they understand how our legal system works, and might have more, one, they might have more faith in it, and two, might feel more willing to contribute to changing it and making it better.
Brilliant, thanks very much. Right, I'm going to come back to the panel. You've all got a minute to make your final remarks. But Ella, I'm going to start off with you. Want to make your closing remarks?
Yes, okay, thank you, Izzy. Really, I just want to leave you with the point that I started with, that I think that the discussion about rape at the moment, whether it be the fear-mongering about rape culture, whether it be the demands to undermine innocent until proven guilty and trial by social media, and that I believe her campaigning that we saw, not least with the Belfast rape case recently, but the kind of push that women must automatically believe, right down to calls to make all complainants and those who are accused in rape cases anonymous. The whole discussion about how we deal with rape at the moment, I think, is deeply flawed, because what it does is central to all those arguments is suggest that women have no agency, and specifically that once they have had something like this happen to them, which is a terrible thing that shouldn't ever happen to anyone, let's not get that let's get that straight, that once that has happened to them, that they fundamentally change, that their agency is removed forevermore, because they are forever a victim and no longer Ella Whelan, but Ella Whelan, a rape survivor. And that's a qualification that's quite serious for a woman's understanding of herself. But that the real way that we should deal with this is by saying that you can, at the same time, condemn this act as an act that society thinks is wrong and shouldn't happen, and say that the best way to deal with this is to deal with it how the individual needs it to be dealt with, but to say that this isn't the end of your life. This thing that this person did to you is not that is not your book shut, right? That is not going to affect you for the rest of your life. But to encourage people to get over it, I think that is not a controversial thing to say that whatever help they need to get over it, to not let that be part of your life. The push to make rape this thing, this defining thing that happens, either threatens women's lives or defines their lives if they have a victim, seems to me a completely unjust way of dealing with this very unjust thing.
Brilliant, thanks, Liam.
The main thing that I really want to say, and it'll probably answer the question that was asked in the front earlier, I think the way forwards is, you have a lot of media reporting and everything like that, but I think genuinely the way forwards is for the criminal justice system to put representatives of falsely accused people and real victims of rape in the same room, because if you only ever listen to one side, and if they only ever listen to what I said, or if they only ever listen to what real rape victims said, you are always going to only hear one side. That's it. You are always only going to act upon one side's view, experience, and everything like that. And I think for something that, a lot of the questions have come out and said confusion about rape and things like that, they will be able to tell you exactly what they've heard, how they've, people in their support groups, people that they've met have defined, rape, and how it would contrast to how it's being defined now. And I think that would be a lot more productive than constantly bouncing between the two, because it seems as though now we've gone to one extreme to correct mistakes of the past, like my mum was speaking about, that we are making convictions easier, as Matthew said. And it's at a point where now we need to go back into the middle somewhere, because it's gone from one side, it's not worked. It's gone to the other side, now it's still not working. there's only one other way to go, really, unless we want to bounce it all the way back, and then we're just going to keep going backwards and forwards. And one last thing is, I have to answer your question, I'm really sorry. It was about, exposure, I suppose, really, to the fact that rape does happen. Somebody on BBC Scotland literally put out that somebody had handed them a note on a train that said, smile even though the world gets you down, smile even though you may want to frown. She started publicly accusing him of sexual harassment. He got off the train. He didn't stand over her while she read the note. I have absolutely no doubt that wasn't intended to sexually harass her. Otherwise, he would have probably stayed. He would have asked for a number. He would have taken it further. He's never going to see her again, probably. But this is my point of, she defines that as sexual harassment. Anybody else in this room probably wouldn't. Some might, but that's where it's up to interpretation. And if you give people clear guidelines of exactly what is and what isn't, that's where the difference comes from. Otherwise, you are exposing them to, when the media do sensationalise things, it's just going to make it worse, and that's all they're going to rely on.
Brilliant. Thanks very much, Lee.
Law classes at school on what consent is. I think your confidence, sir, that if people knew more about the criminal justice system, they'd be less afraid of it, is rather misplaced. I think the more knowledge they have, then the more worried they might become. Is that enough?
Brilliant. That's great. I love it.
But what would be useful is an understanding of law and a recognition that beyond all reasonable doubt is a high bar. And what we're often talking about here is, as I described it earlier, is quite messy interactions around which getting to the truth is not straightforward at all. 2 quick points. The online environment, I think, needs a bit of unpicking, and the point was made. There are elements about that cause me a lot of anxiety about behaviours and activities online that we don't know enough about now. And the final point, really interesting point about, there are two people in fact made points about different standards. I am not so sure. I knew where the boundaries were when I was younger. What people probably did was push those boundaries and be a bit predatory at times, knowing they could probably get away with it. But most people knew the essential boundaries of a lot of the human interactions that they were having. I do not believe that minister, who I could name, putting his hand on the person next to him in that meal 19 years ago, that the norms were different there. I never sat there and put my hand on somebody's knee during a meal who I didn't know. And so I think I don't think the standards are different. I think some of the dynamics and the boundaries we're putting on them are more overt and clearer. But I think norms of behaviour and where the law stands is still pretty clear. It's pretty clear then, and it's pretty clear now.
Brilliant. Thanks very much, Rob. And Hannah, if you want to wrap us up.
So I would agree really that the bar is set very high. It is beyond reasonable doubt. And with the statistics that I outlined in my opening introduction, the bar is so high, in fact, that very few cases in reality do make it through to court. So we have a a rate of around 6% of cases that are making it through to the court from those that have been reported to the police and recorded as crimes. So that doesn't include all of the other sexual violence that doesn't get reported in the first place. So for me, the fundamental issues around the system are reflected in those statistics, and that is where we should be focusing our concerns going forward.
Brilliant. Thanks very much, everyone.
Thank you.